Urgent matter, Your Lordship, AB, Your Lordship. The petitioner is the AP president and he is apprehending arrest. If possible, today or tomorrow, Your Lordship.
In your bench.
Less than 7 years. Less than 7 years.
Mention maybe
Even if it is less than 7 years, that is
he mentioned. He mentioned means senior bench.
Senior bench. Sushmita Khan. Problem.
I beg to mention item number 34 also from the daily list. I'm on interim my lord. I've inquired my CD not received. KJ not received. After vacation. Lord.
interim order passed earlier to continue.
Yeah, bless. May I please, your lordship?
Debt to level.
May I please, your lordship? I beg to mention item number 29. In this case, the CD is not available. The interim may be continued.
Same order, 29.
Obliged. I know.
Hello, delivery of judgment, right?
My lord, item 19 may be passed over for the day, my lord.
Item
19, my lord. Next week, my lord, any day, my lord.
did you turn it council? Is the matter again on?
19 January.
May it please, your lordship. Lordship, I beg to mention item 17. Lordship, Mr. Sarfraz Nawaz is suffering from recurring health problems. Consent is taken from the other side. Kindly adjourn the matter for the day and fix any date next week, Lordship.
List again on.
Much obliged, Lordship.
For pronouncement of judgment. 12/62 of 2020.
Connection হয়েছে Bail is allowed 1 lakh to securities.
For 141 of 2024.
Bail है I think there's some confusion regarding the he has mixed up the criminal petition is dismissed.
Pleasure.
Petition is dismissed.
Then 50.
Sentence is suspended. Bail of 50,000 1 security.
Deeply obliged.
Item 54.
Yeah, please, your lordship.
Bail application is allowed.
Pleasure.
What was the delay?
Item number one.
Wrongly listed.
My lord, should be listed hearing column, my lord. Wrongly listed as a motion, my lord.
Earlier CD was called for.
It was called
So
for.
whether CD is received or not, that we have to take instruction. So day after tomorrow, we'll
Day after tomorrow.
All right.
Hello.
Is the matter in the bail hearing column on 5th?
Okay.
Hello, judgment kata hina bin set up. I pull to him. Okay, money. Alat tilaw turo. Oo.
When anything?
Alat tilaw sa tin kasi. Yan kalau. Venga, men. Kasi i-review daw mo.
Sound?
At kira yan mo. Oo. Oo.
Volume properly to do with you.
Yeah. Nisin khan judgment claim chu puanga. Ta khan kan til nge tel lo pakha.
তাহাঁতৰ মাজত কথা পাতি আছে
Yeah.
And case lordship fixed on 9th of December lordship with AB number
TCR,
two eight
and
double
copy of
nine.
TCR not received, list the matter on
9th of December
9th of December along with
along with 2899 public 25 BA
2899
2899.
25.
Yes. And 4 is the same lordship, same affair.
For same order.
Yes, Lordship regular bail application. There are two petitioners before your Lordship. My Lord, FIR may be seen at page 8 and operative portion, my Lord, may see page 10.
Fake gold.
Lordship. It is suspected to be fake
All right,
gold.
CD.
That is all.
In 12.
Obliged.
Please, your lordship, regular bail application, the petitioner is behind the bar for 30 days, your lordship. The petitioner was working as a lecturer in the Asian Institute of Paramedical Sciences. It is a private institute, your lordship. The allegation against the petitioner is that he has tried to outrage the modesty of a student in a practical class, your lordship. The FI is on page 9. Lordship, the FIR was lodged after 2 days of the incident, and there was no sufficient reason for why the FIR was lodged after more than 48 hours, Your Lordship. And the incident took place, as per allegation, in a practical classroom.
CD.
Lordship, CD may be there, Your Lordship, in item 62. It is AB. This one is BA, Your Lordship.
Yes,
62. We'll call up then.
Oblige, Your Lordship. 62.
কিন্তু লগাই দিব।
May I please, your lordship, regular bail application, lordship. Already charges had been filed and the matter is pending before the additional session judge, Dibrugarh lordship. Next date is fixing for 12/12/2025 lordship. Petitioner is ready to face the trial lordship.
All right, TCR. But you want to appear there, 103.
Lordship. Next date is fixing lordship 12/12/2025 lordship. Kindly consider the bail payer lordship.
Yes. Scan copy of TCR along with CD.
1612.
My lord, this is regular bail application and your lordship will find the FIR at page 9, my lord.
Yes. CD.
Personally, there is no, my lord, ingredients as alleged in the.
No ingredients.
Short date may be given, 23 days in custody, my lord.
It is short date lordship, what is the case there lordship?
Yes.
Date may be fixed.
12/12.
Oblige.
My lord, 7 and 24 are out of same FIR, my lord.
24.
Here in this case, my lord, after 14 years of marriage, my lord, the instant FIR was lost, my lord.
24 is same FIR, no?
Same, sir.
Charge sheet submitted in this case. Bongaigaon হয়ে যাবে। Bongaigaon 241.
Item 7 is anticipatory bail, my lord. He is the not, they are the not primary accused, my lord. Item 24, my lord, he is the husband of the informant, my lord. After about 13 years, my lord, the instant FIR was lodged.
When 11.
7/11. So, sir.
244. 244.
Oh, okay.
If charge sheet is filed, you appear there.
Some protection may be given, my lord.
Till then.
my lord. And in this item 7, my lord, petitioners are the wife and children of the main accused, my lord. He is behind bar, my lord.
Kiran Bosumotari.
Yes. K. Kiran Bhusmutri and 2 others, my lord. They are the wife and the children of the main accused, which is item number 24.
Who is the main accused?
Shohim Ali. 24 item, my lord. And what happened in this case, my lord? After 13 years of marriage, my lord, 2 children already got, my lord.
Wife of main accused. Then Azair is by whom?
Wife.
Another.
Yes, earlier 2 wives.
Yes, earlier 2 wives. Third wife lost the escape. Section 60 to 64(2) does not attract in this case.
Let's call for the TCR then. For both cases. Because in this case, we will anyway have to call.
Short date may be given.
Both item 7 and 24.
24.
Scan copy of TCR.
Item 7 may be granted some protection. My lord.
What protection? 7 days reg.
My lord, police is run after them. My lord.
Without anything, we are not seeing anything.
My lord, actually, there is no any allegation against the item number 7, my lord.
There are allegations I have read.
That too after 13 years, my lord.
16-12.
Yeah. Next part.
No, কোটা নিব।
Item 7 may be some protection.
12.
Not to take any coercive action.
Hardly few days left.
Obvious.
This will be application lordship, non-affair case lordship, report may be called for. Panbada lordship, short date may be given.
Additional PP to obtain instructions as to
Panbada.
whether any FIR has been lodged against the petitioner.
Tuesday. 9/12.
Obliged.
May please your lordship. FIR in page number 13, lordship. The case is rating in the FIR, it is alleged that some amount has been fraudulently transferred by the wife of the petitioner to some accounts, lordship. And it is done in Ulubari, Canara Bank of Ulubari branch. And his petitioner's wife was working there and petitioner was working in Dispur branch. The transfer relating to Ulubari branch, lordship. So I have been implicated in this case only because my wife is working in the Ulubari branch, lordship.
Your wife is who? Jumi Das?
Jumi Das, lordship. He was arrested and he was granted regular bail, lordship, previously. From one account to another 2 account that is the amount has been transferred, lordship. It is done in Ulubari branch. It is stated in the alleged in the FIR that I have conspiracy with that is Jumi Das. Because my rule is not here, because it is clearly written in the FIR that the entire transaction is done in the Ulubari branch of Canara Bank. And the FIR has been lodged by the manager of Canara Bank in the year 2016 also. So at least my interim protection will be granted, at least I can record my statement before the CID lordship.
Page 15 in the FIR lordship, para 3. From conspiracy against him lordship that all circumstances, evidence and relevant record with the bank shows that the aforesaid fraudulent transaction were committed and misappropriated by our staff, Mrs. Zumi Das, officer in conspiracy, which Sri Ranjiv Hazarika, SW, Dispur branch, husband of Mrs. Zumi Das, Sri Paras Garia, proprietor of MS CDS Business Associates, MS Ma Bagola Enterprise, and Sri Podam Kumar.
That means some material is there
Yes,
against
some
him.
materials against him. Lordship.
Maybe lordship, but
Case they may be called for at this stage, Lordship, after appraisal of the case, his
till the calling of the till the receiving of the case, I may be protected also. At least I may be directed to record my statement before CID also.
Your wife's bail order is available.
Lordship, I can give the number, but bail order is not able.
You can download it and come. You can download it.
Yes, lordship.
Pick up after some time.
Right.
Kindly request for some time.
In this matter, my lord, I am apprehending arrest by the Hattigup police station on 19/11/2025, my lord. My nephew was picked up by the Hattigup police station with the help of the Kalapani police outpost. And thereafter, on the next day, he was released, although released, but he was instructed to ask me to appear before the Hattigup police station. And thereafter, my lord, constantly, man, Kalapani police station is calling me to appear before the Hattigup. Although
No
I
FIR.
no FIR, my lord, even though I requested, my lord, but no case number has been furnished to me. Why I was asking to appear before the Hattigup police station, at least it's just matter report may be called for from Hattigup police station, my lord. And interim protection may be given, my lord, no coercive action may be taken. I am ready to appear, but my lord, I am apprehending arrest, my lord. 9/12, lord. Protection may be given, my lord. Coercive action may be taken, my lord, against me in the meantime, my lord.
That is evident fifth.
Fifth. Hello, please.
Instruction from whether any FIR has been filed.
Please, your lordship. FIR is page 8. The informant ballot stated in the FIR that 3% name in the FIR. Informant meet them on 30th of October night. And the FIR name accused person ballot offered him if there's some gold ballot for sale ballot. Thereafter, the informant ballot purchased the gold, the value of 6 lakh. 5 lakhs paid by cash and my lord 1 lakh on online. And the present petitioner, my lord, whatever, is not named in the FIR, but these 3 persons and the informant, my lord, that very night, my lord, take the dinner my sister's house. But it was not disclosed to my sisters what is going on because FIR name accused number 2, my lord, and the daughter of my sister is married, is settled, my lord. And next day, my lord, when the police did not find that accused person, arrested my sister. That is page 14, my lord. Now I am the elder brother of the sister, so the police charging me also, my lord. That is the case, my lord. They took dinner in our house, that is admitted fact. But we did not know their purpose why they came, my lord. Because marriage is settled. One of the co-accused, my lord.
I played for case day lordship, they may be the co-associates of the gang lordship.
The informant also, my lord, not in clean hands, such type of case, my lord. Because if anybody say, I will sell the gold, and secretly he go there, and something happened, then he come, my lord, take the relief from law. These are happening, my lord. So I am not naming the FIR, my lord. Only FIR name request number 2, and my sister's daughter's marriage is settled. And they took the dinner that night in my sister's house. And my sister also taken to the police station. And he's arrested, my lord, on doubt. And police searching me also, my lord. So I may be protect, my lord. And after reveal the case diary, my lord, final order will pass, my lord.
But learned counsel for the petitioner, learned ladies, is an application under so and so. As per allegation, the FIR named accused persons cheated the informant by selling him fake gold for rupees 6 lakhs. So the call for the CD. Present petitioner, having regard to the fact that the role of the present petitioner has not been mentioned, the FIR or the forwarding report of the arrested accused provided on interim bail of rupees 50,000 with securities of like amount. Further provided that cooperate with the investigation here before the IO as in call for the matter again on
9-1.
I would like.
May I please? My lord, at this, sister diary may be called for second bail application.
CD.
Over there.
Maybe, no? 8-1.
Eight. Accept it, any date, I have to.
6 plus 6.
December of the year, one. My lord, kashi prior vacation, my lord, at any date kindly prior vacation, my lord.
18-10.
I live, please.
Okay.
As an AB, I think I should start the case.
No,
Yeah.
I'm not done that.
Yeah, please, don't interpret. I'll just start, then you can tell you can argue. Please, 38 kindly look into, miss. 38, this was the bail which was moved before this honorable court. AB 1085 of 2025. 38. And kindly see the petitioner in this case, Tushar Kashera. The same petitioner again is before this honorable court. Now, if you see at page 39, kindly see page 39, the second paragraph. The petitioner has filed his application of section 482 for pre-arrest bail, apprehending arrest in connection with CBI, AC2, New Delhi PS case number so and so under so and so. Now, when the FIR, I'm just troubling with your lordship with the FIR. If you see the FIR at page 22, this was the first FIR in connection, we came up before this court at page 22. Now, this is related to kindly see 1. If you see at serial number 1, CBI AC New Delhi FIR number RC 2172025A0012. Right, my lord? And the 61-2, and this is 791012. And kindly note the FIR 35-2025. On the left, on the right hand side of the column, 35-2025. Now, kindly see next page 23. If you see,
No, last one, what did you mention?
I'm
Three
sorry,
five
I'll-
date.
I'm sorry,
Last, you had mentioned some number
which one?
just now.
Yes, yes. The date is 35 on the right hand side of
Yes.
the extreme right hand side, 35.
Yes.
After serial number 135-2025. Lordship, right?
Hmm.
Now, if your Lordship turn to page 23, please turn to page 23. Find at serial number 7. 1 is the accused, 2, 3, 4, 5 is an unknown, private, public and private person. Right, my lord? So now, this was moved, and if you see the allegation for a moment at page 27. See the allegation. 27, number 2. Source information further revealed at 16/4/2001 page only. 25C, Prayas Chakraborty. My lord, your lordship can please note down accused number 1. He is the DGM of Oil India Company. Demanded 70 grams of gold ornaments for himself as well for some other unknown public servant from C. Jyoti Kumar. He is accused number 3. Against award, he is the sales and marketing of United Drilling. So and so against award of certain contract in favor of him, and C. Jyoti Kumar Singh also agreed to the demand. So number 3, source information also reveals that 18/4/2025, Jyoti Kumar Singh conveyed to C. Prayas Chakraborty that he has taken the approval of his managing director Sri Kunal Gupta for a bribe of rupees 7 lakhs. Prayas Chakraborty reminded him that he has not asked for cash and once again demanded delivery of 70 gram of gold coin. Instead, Sri Jyoti Kumar Singh told him that due to some reasons, he won't be able to purchase gold and therefore he would deliver 7 lakh in cash. See paragraph 5. The above mentioned act of public servant and private person disclose the permission of comments, so and so, so and so. These are the name. So 5 was unknown public and private person. So we approach, and why we approach this honorable court? Kindly see at page 20. This is search and seizure at my residence. Search and seizure. Lordship got it? Search and seizure.
Page number 23.
Now page number 28. If you see at page 28.
20, you refer to page 20.
28, page 28.
No, before that.
No, I referred, 27 was the FIR allegation. 28 is search and seizure.
28.
Why approach this honorable court earlier? Because there was a raid, there was a search which conducted at my residence at page 28. Lordship got it?
Yes.
Now, at page 32, kindly be taken up at page 32, my lord. This is official in my office of the petitioner at page 32. Now, please turn to page 33. Please mark 1. Page 33, please mark file GM tender number GM 2024 B502 so and so dated 7/6/2024. Lordship got it?
Yes.
This please mark that. And on the basis of that, we approve this Honorable High Court at page 38. Now please see page 38. That's why I referred to page 39. The order passed by at 19/5/2025. And kindly see paragraph 5. It is submitted the annexer C is a search list, and while searching a file number dated so and so was seized along with article. Search is also contain detail of property which also include one invoice so and so issued by so and so. Now this goes on, my lord, narrating that case and everything, and there is an interim order which was passed at page 41. Kindly see page 41. See page 41, 15. Meanwhile, in the interim, in the event of arrest, the petitioner Tushar Kesar shall be enlarged on bail of 50,000. And these were the conditions which was given. We complied with the condition because investigation has to be done in Delhi. So we complied because there is a summon in pursuance to that at page 42 to produce certain documents under BNSS under section 94. If your lordship see at page 42, 24/5/2025. Now at page 44, we submitted the documents at page 44. Lordship got it, my lord? And now my lord will kindly see, when an interim bail was granted, there was an affidavit which is filed by the CBI before this court, and we have annexed at page 46. And very interesting at page 48. Please mark that, my lord, para 7, which is the part of the next FIR which we are before this court. See at page 48, paragraph 7. The interrogation of accused Prayas Chakraborty further revealed that he has received 2 gold chains from petitioner, Sri Tushar Kesar, proprietor of so and so, on 12/4/2025 as illegal gratification for favoring the said firm in awarding a tender worth rupees 3 crores for supply of genset. He admitted to have processed the contract which was awarded during March. The said 2 gold coin have also been recovered and seized. Lordship got it, my lord? Now, thereafter, I appeared before the investigating agency at New Delhi. Kindly see at page, it starts from page 55, my 5 tickets which I have appeared before the IO. I didn't violate any terms as per the order of this court. 55, these are my flight tickets. Now, at page 57, Lordship will kindly see now the order. At page 57, that is 26/8/2025. See at page 58, paragraph 3. It is submitted by so and so learned standing counsel CBI. Charge sheet has already been submitted in this case, wherein the present petitioner has not been accused, thereby indicating that no sufficient material has been found in the investigation against the present petitioner. So now, your lordship has made the interim bail absolute. Therefore, the interim pre-arrest bail is hereby made a subject to following condition. Right, my lord? Now we are before this court because of this second FIR, which is at page 60. Kindly see page 60. 60. Now, if your lordship looks into serial number 1, RC fire, earlier it was 12, now it is 0019. Lordship got it? Now the dated is earlier 35, it is 18/8/2025. Now, place of occurrence, kindly see, my lord, if your lordship looks in the first FIR, place of occurrence at page 22. I am just troubling your lordship with page 22, correlating with page 60. See at 5, serial number 5. Below place of Noida, UP and Dibrugarh, Assam. Lordship got it, my lord?
Yes.
Now please see at page 60, place of occurrence. Page 60, Tinsukia, Assam and other places. Now, there was an unknown person which I came before because of raid. Now they have made an accused in this case by putting my name at page 61. See at page 61, my lord. 61, Prayat Chakraborty is already there. Lordship has seen that. 2 is Tushar Kesar. Now, because of the same incident of gold chain, 3 crores, Lordship has seen that. Now, see the allegation contents at page 63. I don't know, there is a point of harassing. You cannot harass a person like this. See at page 63. A case RC so and so dated 3/5 of BNS so and so was registered to CBI against the Prayat Chakraborty, Deputy General All India. During the invasion, trap was laid down by so and so during the trap proceeding. Jyoti Kumar Singh, Deputy General Manager, United Drilling, Prayat Chakraborty were so and so after delivery. Bribe amount to 7 lakh. That's the same story. The said bribe was paid to Sri Prayat Chakraborty, Jyoti Kumar Singh. Company Manager, United Drilling Tools was awarded a contract of winch machine by All India so and so. Investigation of the case has revealed that Prayat Chakraborty joined All India so and so and so. Now, kindly see, these are same replica of the earlier. Now see third paragraph. During interrogation, in presence, independent Prayat Chakraborty has revealed he has received 2 gold chains. Now that's the same, my lord, all of you seen what they have, CBI has stated in their affidavit. From Tushar Kesra on 12/4/2025, Tinsukia. Now the place, Tinsukia, 2 gold chain is the same part of the earlier where they have revealed that same affidavit. As illegal gratification favoring of firm, namely so and so, owned by Pradeep Kumar Keshra against a tender worth rupees 3 crores for the supply of genset awarded by Messrs Industrial Trade Agency. Priyat Chakraborty have processed the said contract. The said 2 gold chain has recovered and seized by CBI on 3/5/2025 in presence of so and so. As seized. Now, if you see after the second paragraph, 3 lines, see Tushar Kesra as well as other document collected during the investigation, established, has prima facie established, has demanded illegal gratification bribe from so and so in lieu of tender number dated so and so, award 3 crores awarded to so and so. So this is the same subject matter where once this honorable court has granted an interim, your lord, they filed an objection bringing this 3 crores also a part of it. File also has been seized. Earlier it was unknown where we came because there was a search and seizure. Today you are making me another second FIR. And the place is Tinsukia. Now the contents almost the same and you are harassing us again. So my limited prayer is that the case diary be called for. And in the meantime, protection should be given by this honorable court, madam. Already I have been, your lordship has granted. So if your lordship for a moment, again troubling your lordship, kindly see the affidavit, the objection which they have filed. Again, sorry for troubling it. See again, my lord. 48, kindly see, my lord. See 48. See 48, paragraph 7. See, my lord, 7. See 7. This is a part of the earlier my lord, the bail. Interrogation of has further revealed 2 gold chain from petitioner so and so in the on 12/4 as illegal for favoring the said firm in awarding a tender worth to be 3 crores. This is what you have, and after that, looking into it, and the file has also been seized. So this is my humble submission, my lord. Let a case diary be called for, and your lordship has seen it. I have demonstrated. 3 crores, same. File
So the
number.
earlier case in which the charge sheet was filed,
Yes,
excluding the present petitioner,
yes.
that allegation was same,
Same.
2 gold chains.
Same. My lord, the affidavit has been brought by them. 2 gold chain, 3 crores, all same. Now what they have done, from Noida, Dibrugarh, they brought it now of a place of occurrence is in Tinsukia. And earlier I came up before because my house was seized, raided, and they found these 2 gold chains from Priya Chakraborty. And he was asked, he said that this gold chain I have received from so and so.
Yes.
May I please, your lordship? At this stage, I have received the copy only yesterday. Not in a position to take any instruction. I'll reply as well as PD. However, I would like to apprise your lordship that this is the outcome of the larger conspiracy of the said tender. And in this,
Either you are in a position to submit or you are not in a position to submit.
earlier his name was not there. His name was not in the FIR. He was not named FIR.
But
in the
after
earlier
investigation,
FIR.
charge sheet was submitted excluding him.
Yes, excluding his name. And later on, due to the larger conspiracy, something more is revealed out. And in view of the
But the incident is same.
the private person and the private organization, commercial organization has been also included in the PC Act under section 9. Under section 9, 10 and 8, your lordship. And thereafter, in view of this larger conspiracy, which is revealed from it's paragraph page number 64. In
So
which
what is new about it is you tell us at
It is- it
paragraph
is written
7,
there.
at
Yes.
paragraph 7 of your earlier objection filed in the earlier case, there also you said interrogation revealed that this petitioner had
was-
done this,
That is why I need.
and
some
yet
time.
you filed the charge sheet excluding
I
him.
need time to. So
Yes,
that
and then he has to be
so that
protected.
we can
He
testify.
has heard
this
Mr.
genuine
Learned
interest
Senior
case.
Counsel for the
And
petitioner.
in paragraph
So
number
learned
60,
standing counsel for the
64,
CBI decision application for pre-arrest bail and so and so. The allegation as contained in the
So at this stage, it
instant
is in the nascent stage.
FIR.
Stage. If any protection
That-
is granted without our filing of reply, it will cause a prejudice to the investigation as well as the organization also, Your Lordship. Page number 64 may kindly be seen. 63 and 64. And that is why section 9, 10 and 12 is attracted. It is an independent section for the commercial organization. But I may be permitted to file, take a appropriate instruction and to file some paraphrase reply.
Where is the FIR?
It's at page number 60, Your Lordship, new FIR.
60.
60.
And the operating part starts from 63, 64 and 64, up to 64.
Market you. Appears that an earlier FIR was registered being number. What was the number of the earlier FIR?
Yes, earlier FIR at page 22, 12, RC 217202580012 at
Yes.
page 22.
Page 22, FIR number
22.
dated so and so. Containing basically the same allegations against the present petitioner as is reflected in the present FIR and the earlier FIR ended in a charge sheet which excluded the name of the present petitioner. On perusal of the present FIR, appears that the allegations are substantially the same. Para. Having regard to the above, provided that intent of his arrest shall be released on interim bail of rupees 50,000 with 2 securities like amount to the said. Is further petitioner shall appear before the litigating officer within a period of 7 days,
10 days.
10 days from today, and shall cooperate with the investigation. Before this paragraph, you read, Miss Mrs. Standing counsel.
Standing counsel.
Poses the prayer for interim relief on the ground that further instructions are. When do you want?
Now protection has already been granted, as Your Lordship pleases.
Take your time instead of having the matter again and again weekly, as is the experience with CBI. Take some time. 2 weeks.
For the convenience of Lordship.
2 weeks. 2 weeks, 10 days. He has got 10 days time, so let us have it
It be
after
fixed on
that.
then 18th.
What do you call it? Call for the what? Case diary. What do you call case records?
Your lordship pleases to see the case diary, definitely I am supposed to bring. I will ask them to bring.
What else should we see?
And parawise reply we need to file.
Right, parawise reply along with case diary.
Deeply oppressed. Okay.
Kindly item number 9.
May please your lordship. We have obtained the copy of the
So this is about material against you, your wife only.
Yes, Lordship. And in para 10, it has been stated in the bail order that is, other co-accused have been granted anticipated bail, Lordship.
Yes. But had learned counsel for the petitioner. Additional PP. Application under so and so. Who has allegations? Taken in alay. Long. But the allegations contained in the FIR 1. Jumi Das.
Jumi Das.
Jumi Das. An official of which bank?
Canara Bank, Ulubari branch.
Canara Bank, Ulubari.
Now job has gone, Lordship.
Was an officer of Canara Bank, Ulubari branch, had misappropriated an amount of rupees 3 lakhs by fraudulently closing KDRs. What is KDR?
KDR. What's it? KDR. Probably scheme of a bank, Lordship. I'll share.
KDRs, the KDRs of the customers of the bank. The present petitioner is the husband of the
Lordship, Kamdhenu deposit receipt. KDR.
KDR, that is bracket Kamdhenu deposit receipt. Petitioner is the husband of the main accused. Call for the CD. It is submitted that the main accused has already been granted regular bail and a perusal of the order dated 17/9/25 in bail application 2995 passed by this court indicates that other co-accused have also been granted pre-arrest bail. Having regard to the above, it provided that in the event of his arrest, the present petitioner shall be released on interim pre-arrest bail of rupees 50,000 with 2 securities of like amount to the satisfaction of the arresting authority. Further directed to appear before the IO within a period of 7 days from today and cooperate with the investigation. List the matter again on
8-1.
Item 10.
Right.
Lordship, this is a second bail application. Earlier it was rejected. The new ground is that the other accused person has been released on bail in a BA matter. and the mandatory notice under section 40A is not yet been served upon the accused person, which is the violation of Arnaz Kumar case. And also the up-to-date case diary is being required as the driver is still absconding, Your Lordship. If he is being arrested, if any.
And this is AB.
Yes, this is AV.
It is the question of violation of 48 now. It is only at the time of arrest that it is to be given.
The Arnaz Kumar says in both ways they have to be served. After they have not been served with notice to appear before the IOs.
That is 35.
And other, Your Lordship, up to the case diary is required because the driver of the said instant case is still absconding. And if he's being arrested, if any statement
All right,
is
case
being-
diary, up to date case diary we call for.
All right.
May I please, Your Lordship? There is 10 petitioners before the issue, all are family members, Your Lordship. This FIR is page 12. It's a counterblast of our FIR, Your Lordship. We have lost FIR on 27 and the instant FIR was 28. An incident took place in our house. The informant side came to our house.
Where is the present affair?
12, Your Lordship. There is some exaggeration in the affair that we have used sharp weapon and attack. Page 12, Your Lordship. This party was going in my house and they came and broken our DJ, Your Lordship, music set, and that quarrel took place. Both sides received simple injuries. Your Lordship. They have some exaggerated. They belongs from different village. Then 1.5 kilometer distance. We are from Haldibari place and they are from Kasbari place. And our affair is 18. We have lost 27. Then took place in our house. Some reason that both sides received simple injuries. Important CD may be called for and both the CD may be called for.
Call for the CD including the CD of which case?
It is, Your Lordship, support gram PS 66 and support gram PS case number 67. Till date, we are protected, Your Lordship. We are all family members, Your Lordship. 10 petitioners, all are family members. An incident took place in our house, Your Lordship. And marriage party was going, they came and
We have passed the order. After that, we will not hear your prayer.
17-12.
Lordship, earlier report was called for.
We have not received any report, Lordship. So, what about that?
Which police station? So many dates. Since 26/9/25. Has communication been sent?
10, Lordship. Tomorrow, day after tomorrow. Lordship.
Report not received. Release the matter again tomorrow. Okay.
Oh.
No report tomorrow means personal appearance. Inform.
This is a 438 application, my lord. This is offense under section, my lord, 61, 308 and 351 and 3, my lord. But so far, my lord, 308 and 351 is there, my lord. 308 is nothing is reveals from the FIR, that is in page 12, annexure 1. It is, my lord, specifically by one, my lord, the Pramod Sharma, the manager of my lord, Puspanjali Banija Limited, he has lost the FIR in reference to the earlier, my lord, police case that was registered as a, my lord, 545 of 2025 relating to attempt of robbery in his there Gudan. And subsequently on that count, my lord, the another 2 person, namely, my lord, the my lord, the Rantu Panipukan and the Assam, Vikas Assam, my lord, they have threatened my lord, him demanding money and other things with the help of the present accused petitioner before lordship. And in that connection, my lord, all two persons, they were arrested, and kindly lordship will turn to page, the forwarding. That is on page 16, my lord. Lordship got it, my lord?
Page?
Page number 16. Well, Lordship will got, my lord. The last but second para, my lord, the name is specifically mentioned that my lord, they two persons, Rantu Panipukan and the Vikas Assam, they both were arrested and they were forwarded to the my lord, the judicial custody, but subsequently they were released on bail, my lord. The where it is next para, next page, my lord, in page line number 2, my lord. It is specifically stated that they have been found involved in the connection of the above mentioned in connection with this said case, my lord. But so far, my lord, our involvement is there in forwarding, nothing has been whispered. And so far, my lord, 308 is concerned with no any such type of offense has been committed, my lord. No money has been taken out or any other has been taken by me or whatever it may be. My lord, in that case, my lord, I prayed, my lord, let me city may be called for, my lord, I may be protected, my lord. And so far, the membership, they are saying that we are a member of Assam Lasit Sena. Well, we are not the Bir Lasit Sena member. We are the member of Bir Lasit Sena Assam. These are both are differently two identity. So
With the same activity.
my lord.
With the same activity.
No, my lord, this is not the same activity, my lord. We are different, but now the lordship is aware. Lots of my lord, cases has been registered against those, my lord, the activists of the BSNA. They are only because of some politically motivated. My lord, this is nothing else. My lord, only to give some, my lord, the treatment to the person's concerns so that they may be not involved in such type of activities. My lord, but so far my part is there, my lord. I have no involved. Only to my lord in the behest of the one of the MLA, local MLA, and with the instruction of the superior authority, my name has been implicated, but no specific allegation is made out in the affair, my lord. And if
Case day only, Lordship.
and in that respect, my lord, in earlier occasion, my lord, your lordship, my lord, in honorable court has in the same facts regarding the 308, my lord, they granted PLS bail, my lord. This is any other case, my lord. Lots of cases has been. Case number is different, but the petitioner is different, but the allegation are more or less, my lord, same.
Another case, Lordship has rejected the pair of granting regular bail, Lordship.
That case, wherever I will not forwarded to lordship, that is a more serious, where found some receipt. And in my case, well, nothing was there. Only the involvement of the two other person, except my lord, our part was totally silent in the forwarding. I pray, my lord, I may be protected and let the PP may produce the CD. By this time, lordship will finalize the whatever will be come.
Heard learned counsel for the petitioner. Heard learned additional application under doing so. The allegations as per the FIR are that the petitioners are members of an organization called Bir Lasit Sena, and they have been issuing repeated threats to the informant and other staff members of the informant's company and demanding money, threatened to kill them. Submitted by learned counsel for the petitioner that specific allegation has been made against the present petitioners. The main accused have already been arrested, and in their forwarding report, no role has been attributed to the present petitioners. Call for the CD in regard to the submissions of learned counsel for the petitioner. It is provided that in the petitioners so and so shall be released on pre-arrest bail of rupees 50,000 with one security each for like amount to the satisfaction, provided that here before the IO within a period of 7 days from today and cooperate with the invest. Please the matter again on
9-1.
Master placement. Copy to everyone.
May I please, Your Lordship? This is an application under Your Lordship section 482 of BNS, Your Lordship. The petitioner, Your Lordship, has preferred this application, Your Lordship, on apprehension that he may be arrested in connection with FIR dated 26/11/2025 at page 10, Your Lordship. May I read, Your Lordship? With due respect, I would like to inform that I am working as the president of Bharatiya Janata Party for Manipur Monol. Yesterday on 25/11/2025, above mentioned accused person by making a fake letter, Bharatiya Janata Party spread a fake news that I have collected so and so from an unnamed dhaba for a tribute. So in the name of Lady Devinder, the above accusation has circulated the image in the press and social media, and my party's image. The letterpad was released in the social media, and the letterpad which I actually use for part of, and they are not similar with each other. Moreover, I'd like to inform you that the above accused person has previously sent me that publicly. This is the FIR, Your Lordship. It was registered under section 3193. Only, Your Lordship, 336(4) is 7 years, Your Lordship. Otherwise, Your Lordship, it is not, there is no question of arrest since it is under 7 years. But police has been visiting my house, Your Lordship, without issuing 35(3) notice, Your Lordship. That's why I am before. And secondly, Your Lordship, this is not, I have mentioned here, Your Lordship, I have received it from some other person, Your Lordship. Then I forwarded it to one, Your Lordship, person, Your Lordship, who is in Your Lordship reporter of a particular channel, Your Lordship. And in fact, Your Lordship, when he has first lodged the FIR, that is at page 19, Your Lordship. This is the first FIR, Your Lordship. My name is not even there, Your Lordship. It was against the channels, Your Lordship. This was also, Your Lordship, received by the concerned police station, Your Lordship.
You are a reporter of this channel.
No, I have nothing to do with this, Your Lordship. Neither I am a reporter. I have received one from, I have mentioned the name from whom I have received, Your Lordship. I forwarded it to a reporter, Your Lordship. He made it a Your Lordship news. And thereafter, Your Lordship, first FIR, my name is not there, Your Lordship. Subsequently, Your Lordship, by naming me, he filed the second FIR. Your Lordship may call for the case there, Your Lordship, and in the meanwhile, some protection, Your Lordship. Otherwise, it is custodial interrogation, at least in this case, is not required, Your Lordship. I will cooperate with him.
Mr. Learned counsel for the petitioner or learned additional an application under so and so. Application is reflected in the FIR. Paragraph 2. Call for the CD. Having regard to the nature of the cases. In pre-arrest being 3,001 security. Sinners will appear before the IO in a period of 7 days.
Lord.
Then cooperate with the investigation.
Deeply.
May I please, Your Lordship. My lord, this revision petition has been preferred against the order passed by the executive magistrate under section 133 of CRPC, directing the petitioner to remove the fencing put in his private land, my lord. The impugn order is at page 42. May I read, my lord?
Page?
Page 42, my lord. May I read, my lord?
This is an order of 2022,
My lord.
blocking of a road.
My lord.
What is the situation now?
There is a stay order, my lord. There is a stay order from this.
So the road is still blocked.
My lord,
The road is still blocked.
not blocked. Not blocked. A certain portion is there, my lord. And my lord, in this case, my lord, there is a public road in existence, my lord. They are claiming the road over a private, my lord, in a patta land, my lord. This is the problem. If your lordship come to a page, existing road one, yes, south side, western side, at page 33, my lord. Page 33. This is my lord trace map. And if your lordship will see that dot portion, that is the road, my lord.
But you remained absent. Why did you not appear?
My lord,
You remained absent before the magistrate.
the earlier occasion, I could not appear. Yes, that is there, my lord. Thereafter, I preferred a revision petition before the session court, and that was remanded back, my lord. And thereafter, this order was passed, my lord.
There also you did not appear. Read the first line.
Both parties absent, my lord. But, my lord, in my written objection, I have taken that plea, and I have spoken about the test map itself, my lord, and existence of the public road within the western side. So the learned magistrate ought to have considered all these facts, but he did not consider at all, my lord. And if your lordship come to their petition, my lord, that is at page, vernacular is at page 14, my lord. Their petition is at page 14, that vernacular one, my lord.
Yes.
Their petition is at page 14, that is vernacular one, my lord. At page 14.
Yes, respondent, it appears to be a prima facie Miadipatta land.
Arsdale Road was enclosed by the petitioner.
Hmm?
Arsdale Road was enclosed by the petitioner.
What Arswell Road?
Outside
Western.
western
You
side.
are asking him,
That part.
which he has encroached.
That road was enclosed by the petitioner. And this is his own road, which he allowed the public of the locality to use that road.
He may disallow. Now he may disallow.
No, lordship, then he is to clear that road. Arsdale Road.
Public road.
Public road.
Public road, why he is to clear? That is the government's business.
To pass the public through that road.
No.
He enclosed that road.
So what is the DC doing?
Lordship,
Even any government road is encroached, should the government wait for some party to come?
and lordship, subsequently order dated 31/8/2022, an order was passed by the learned additional district magistrate. And that order nowhere stated by the petitioner here in the petition. This is the copy of that order, lordship.
But have you filed any affidavit? Bringing on record? How do you agree about this order?
I don't know, just wrote.
Not agreeable, then you have to file it in the form of affidavit.
Both parties were present on that day.
This order is 26/10/22. Earlier one?
Prior to their filing of this petition, both parties were present.
No, impugned order is dated
Impugned order 31/10,
31/8/22.
31/8/22. And this was passed on 22/10/22. And they filed this revision petition on 28/10. 28/10/2022. And no word stated about this order.
Are you in touch with your client?
My lord?
Are you in contact with your client?
No, I'm not directly, my lord.
Not directly. Indirectly?
Indirectly, yes. I have to take instruction. And otherwise, it seems to be a execution. I think this is executing part, my lord.
Learned counsel for the petitioner prays for time to obtain instructions regarding the present state of affairs with regard to the disputed land. Is the matter after 4 weeks. Learned counsel for the respondent may file affidavit bringing on record any order passed by the authorities which is not included in the present petition. Just again.
22. Oblige.
With the lordship. In case not the petitioner of the lordship is seeking quashing of the FIR as well as the charge sheet, my lord. Only turn to case 13. Case 13 is the FIR, my lord.
Yes.
Here it, my lord. With respect, I would like to inform you that on 3/6/2022 at about 11:45 night, I was coming with respective additional SP of Biswanath district on our way back to Biswanath from Helem, Gopur on 15 number National Highway towards the, after completing the official duty
we noticed one person lying down with the bike near Rotua overbridge under Jinjia police station. And we assumed that it was an accident and stopped the vehicle to help the person. But the person got hyper and profaned me and my colleagues with filthy language and prevented us from doing our official duty. In intoxicated condition, he fought with us, me, and threatened me. The allegation, my lord. Thereafter, my lord, he was taken to the police station, legally examined. Fact of the case is that the petitioner before Lordship is a, my lord, pharmacist by profession, my lord. On that day, my lord, a person from a neighboring village, my lord, asked him to administer, my lord, saline. And after administering the saline, my lord, when he was returning home, find the facts at page 3, my paragraph 3, my lord. And 4, my lord. Same facts, my lord, there is nothing. How can a unarmed person, my lord, can dare to fight with police personnel, my lord? Cannot be. Personnel also, they were not on duty. They were, after completing the duty, they were returning. Action of duty. Kindly see the medical report of the petitioner also, my lord.
So different issues, those are matters for trial. What is the ground on which we can interfere?
I was beaten up by the police personnel, my lord. And the police personnel, my lord, was never medically examined. Unarmed person can dare, my lord, to attack the police personnel, my lord. They came in a, my lord, Scorpio vehicle, my lord. There are many police personnel, my lord. Hearing, my lord, as there is an interim order.
Yes, PP.
That will also come, my lord. Matter may be hard and finally disposed of, my lord. There is a crossing of search sheet, my lord. The search sheet has been submitted.
January, my lord.
I'd learned counsel for the petitioner, the additional PP. Is admitted for hearing, release the matter on month of January.
Interim order, my lord.
Interim order passed earlier to continue.
Obliged.
The next date.
I think.
May I please, your lord? In this, a scan copy was called for, my lord, on last occasion, while matter was taken up by your lordship. But the story goes like that. Their petitioner and the informant were in love relation and ultimately they got married, my lord. But because of some differences and there was the allegation, affair lost by the wife, that my husband is not in touch with me and he's contemplating to marry again. Then thereafter, my lord, court, in view of that case, my lord, 498A and 376, Honorable High Court has granted the husband bail, and ultimately the interim bail was made absolute. And lastly, my lord, the IO has submitted charge sheet 376 and 417. And against that,
There
my
was
lord-
some report to be obtained regarding expiry of the informant.
yes, the informant.
Any report?
It is not come, my lord.
And further, whether the informant of the case, Lipika,
Deepika,
is,
not-
has expired.
That is to be obtained through my lord trial court, my lord, because the matter has already been.
trial court also failed to bring it because session just, I have annexed all the orders. Time and again, I was asked, you bring, they said we could not procure it. This, my person is not available. That is the question. That's why your lordship was wanted to confirm whether it is been possible to procure, madam.
Let them on the scan copy be called for, my already been called for, my lord, it not received today.
And copy of TCR is not received. Report of IO is also not. OC, Silchar PS is also not received.
To pray for further proceeding may state, my lord, because charge has been already been framed most illegally, my lord, without following the procedure of law.
Let the scan copy come, my lord, that is interim plan may be considered on the next day.
How can you, the petitioner, the informant is no more in this world.
That is your.
How case will be 370, his case will be proved.
Then
my
you submit some death certificate.
Where from my friend?
Then where from?
Arre,
you will pay?
You have filed the case. London Session Court has failed to procure the certificate. Time and again, there was a direction to produce it to the IO. Till then, further proceeding may state because your lordship is feel that there is a material, your lordship can vacate it at any time. my lord.
Is submitted that charges have already been framed by the learned, which court? Sessions Court.
Session Court,
Charges,
Kachar
my lord, in the month of May 2025, my lord.
Yes.
Already more than 5 months has elapsed.
but it is not proceeded.
No, not process. This is here some reason, my lord. Let the scan copy be verified, my lord.
No, if you can prove that the case, there
No,
was an
what we-
evidence has
we have-
been
we have
taken.
nothing to prove.
But I have
We are
annexed
submitting on
all the
record, but-
witnesses' statement.
We have nothing
There
to
is
prove
no
anything.
case against me. Nobody has, there is whisper against me.
We are just assisting the court, my lord. We have nothing
No,
to
you
prove.
kindly,
The
Mr. Borua,
investigating officer has proof. That is why he has submitted the.
that is, the investigative officer has wrongly submitted. That's why court is there. Mr. Borua, please read the evidence that I have enclosed. Thereafter you submit. If you can bring out any material, I will withdraw the case.
We have to know, my lord, what is the status of the case, my lord. So charges frame in the month of May.
Charges have already been framed in the month of May.
28/5/2025, my lord.
On 28/5/25 under section 417(376). The said order framing charge, the learned additional session judge FTC Kachar has noted that the defense counsel did not press hard upon the issue of discharge, and hence the court has framed charge after perusing the material on record. Thereafter, the trial has not proceeded, and it appears from the orders passed by the learned trial court that despite repeated directions, the IO has not furnished any report with regard to the death of the complainant. So, perusal of the order dated 22/3/2021 in AB 389/2021, whereby interim pre-arrest bail was granted to the petitioner, indicates that the court had found upon perusal of the statement of the victim girl, aged about 32 years, that he has been maintaining a relationship with the petitioner since 2006. He also underwent marriage ceremony in a temple and led conjugal life as husband and wife. And there was no sufficient incriminating material requiring custodial interrogation of the petitioner. Para. The repeated failure of the IO to submit the report regarding the death of the informant would prima facie indicate that not available at her given place of residence for whatever reason, because of which the trial has not proceeded. Pending receipt of the scanned copy of the TCR, considering the aforesaid facts, deem it proper to stay further proceedings in case number.
Case number, my lord, session case number 105 of 2012.
Pending before the
Additional session judge, Silchar Kachar,
FTC.
FTC.
Issue reminder for scanned copy of the TCR and report regarding death of the informant from the OC Silchar PS. List again on so and so.
That report may be called for through my lord, registry, my lord. Yes.
Report.
Hearing date, my lord.
Report regarding the report from the OC Silchar shall be called for by the registry.
January. My lord,
That
it's
is-
too long.
Okay.
I have to face the trial, go to the court.
Date.
Date. No problem.
Till it can about that, my lord.
Till the next date.
I don't know.
Made the lordship. Application for closing the FIR as well as the charge sheet. Your lordship will find the extra one, my lord, Azahar at page 13 of the petition. Repeatedly, my lord, the informant is related through her husband to the accused, my lord, the petitioner before your lordship. Page 13 is here. The petitioner's case is that, my lord, actually it was a dispute relating to the ancestral property. Under some pretext, I was invited, my lord. I am a person of the discipline force, and even her husband is also a person of personnel of the BSF. I was invited because the next day I was leaving, my lord. And thereafter, my lord, when there was no solution, no resolution, rather, my lord, this came to be filed. And now the charge sheet, my lord, that is at page 22. That may kindly be seen.
Page?
Page 22. Particularly, my lord, the bottom paragraph, my lord, may I read out. During investigation, statement of the victim was recorded before the court and victim was medically examined and collected the medical report, and after going through the medical report, it is seen in the opinion of the doctor that the doctor has not identified any sign of sexual assault. Although the case was registered under section 447376511 IPC, but after recording the statement of victim during investigation, the case was found established under section so and so, so and so, so and so. Charge it is laid. So there is apparently no medical evidence. Your Lordship 376 will require, my lord, some kind of penetration, my lord. There is no allegation, my lord, of that. I have given the vernacular also, the charge sheet in vernacular. My lord.
Where is the statement of the victim?
Victim statement, my lord.
Here.
That, my lord.
So
that is-
just going through the scan copy, my lord.
And that apart, my lord, number of orders have been passed calling for the CCTV footage, my lord, which is mentioned in the charge sheet, my lord. Page 22 itself, my lord, but that has not come, I believe. Last date it was not there. That date, before that also that was not. That is to, my lord, that his entry and, my lord, exit to show that, my lord.
Even if 376 is not there,
354 maybe, my lord. Maybe
maybe,
354.
yes.
Not
We can't
370,
cause the entire charge sheet.
my lord.
We can't cause the entire charge sheet.
But at least 376 shouldn't be there. That is my suggestion. Both from her statement in the FIR and also this medical evidence.
One sec.
No statement.
161, she said, my lord, attempted, my lord, but she somehow, my lord, save herself, my lord. He remove her coat cloth, my lord, and push down in her bed, my lord. Then somehow she, my lord, save herself.
Not bad, nothing, my lord.
376 is with 511. So
376, my lord, cannot come, my lord. There is nothing.
attempt.
It is just an attempt. I
Attempt
have-
does not require
in
penetration.
our own words.
This is related and crossing petition. Earlier they have filed one. Was anyhow dismissed. And this is the second. In earlier petition, they challenged the FIR. And subsequently, they are challenging the charge sheet and the order of cognizance.
With liberty, man, liberty from the court.
So regarding this, I'm submitting this judgment.
Peruse 164 statement, my lord.
At least the statement reveals attempted rape. Statement of the victim before the magistrate, it reveals an attempt to commit rape.
Then that is the difference with the, what she has stated in the FIR, my lord. I am not saying that, that
The
is,
matter of trial, my lord. Charge is yet to frame, my lord.
she herself says, my
And
lord,
anyway, this is 376 with 511.
with 511.
It is not
But
376 alone.
medical evidence, my lord, clearly.
Those are matters of trial. You don't need medical evidence in every case.
Maybe a case of 354, my lord. My humble submission, my lord.
That is something you have to argue at the stage of charge. Because prima facie, we are not here to determine such fine distinctions in a exercise of powers under 482 or 528.
164.
Whether this should apply or that should apply, that would depend on facts. There is this argument regarding attempt or 354, 370, 500 is always present in so many cases. It will all depend on the facts of the case. Anyway, we'll see. LCR is here.
All right, my lord. Not so good. My lord, may I just place one judgment, my lord?
Yes, yes.
You will also maybe know Takasar Sahu's case, my lord. State of the Para is 10 and 10, 12, 13.
14.
And 14, my lord. 10, 12, 13, 14. Much obliged, my lord.
Civic. Civic.
That 60, no? But please, your lordship. 438 BNSS lordship application, here in this case, lordship, the petitioner is the register owner of the vehicle, lordship. And the vehicle is seized by the custom, lordship, and subsequently on the date of occurrence, lordship, and the vehicle driver was Anna Sali, lordship. And prior to seize, lordship, and the petitioner already leased his vehicle, lordship, to one Mofidul Islam, lordship. And some currency was recovered from the vehicle, lordship. And subsequently, since then, my lordship, and the vehicle is lying in the police station, lordship. And otherwise, lordship, the petitioner name is not appear in the FIR, and nothing, any whisper against the petitioner and the complaint, lordship, and kindly come to page number 13. There is nothing whisper in the present petitioner, lordship. And lordship, custom, lordship, and issued notice under section 108, lordship, for his statement, lordship, and he third time, lordship, he appeared, and his statement has been recorded by the custom, lordship. So no allegation against at all against him, lordship. Allowed to the handling the zimmer of the vehicle, lordship. He is no connected and nothing involvement at all.
May I please, your lordship? I'm appearing on behalf of Mr. S. Lordship, the petitioner is the owner of the vehicle from where the contraband was recovered, and the contraband's value is 37 lakhs 74,000, which is of high. It is a high value, lordship. In the initial trial, initial investigation, there was a contradictory statements were provided by the petitioner. Hence, there was a possibility of involvement, lordship. Hence, your lordship, the vehicle was the vehicle was under the customs department, Lordship.
My statement, Lordship, and my statement has been recorded, Lordship. There is nothing, any contradiction, Lordship, in the statement recorded by the custom, Lordship. That because I am the owner of the vehicle, Lordship, and what type of contradiction statement will be made by me, Lordship, before the custom, Lordship. Lordship, and for a moment, Lordship, kindly come to page number 17. No purpose will be served, Lordship, and this vehicle will be made in custody, Lordship. Apparently, page number 22, Lordship, the observation made by the learned court below. First paragraph.
Conditions may be imposed.
You lease the vehicle to one Mufidul.
Lordship. And prior to this seized, Lordship, about 6 months ago, Lordship, due to financial scarcity, Lordship, and I could not provide the installment properly. That is why, and I got accident, Lordship, and I'm very clearly in my statement is recorded by the custom, Lordship. And even, Lordship,
That ownership is lying with you. Ownership is still with you.
Lordship, only lease, Lordship, and he is operating, but I have not transferred the vehicle, Lordship. And due to financial problem, Lordship, I give lease. And page number 17, Lordship.
If you have leased it to him, then who is entitled to Zimma?
I am the registered owner, Lordship, and only for
You may be registered owner, but if you have leased it to him, you should have made him a party.
He's fled, Your Lordship, and even my statement is in very clear.
Is the lease terminated? Is the lease over? Or is it still running? No, you will come and say, I am the lazy, I am running the vehicle. I should have been given notice.
Yes, Lordship, the petitioner will be, registered owner will be entitled that because, Lordship, and he is fled away, Lordship, and that because, and as per the statement recorded of the driver, Anna Sali, Lordship, as per the Lordship complaint. So, my Lord, condition may be, Lordship, and even.
He was in the vehicle when it was.
No, Lordship, no. I was not.
This Mufidul.
Mufidul, Lordship, and one Anna Sali driver is, Lordship. I was not there, Lordship. At the relevant point of time, Lordship, and it was operating by Lordship, and page number 14, para number 5.
Red Hat Learned Counsel for the petitioner. Learned representing customs. Application for challenging the order dated 14/8/25 passed by the Kasar. Departmental case number impugn not child, but case number. By the prayer for Zima of the hearing registration number AS 12W 4111 out by the present petitioner as the registered. Council reporting the department fairly submits that it is the registered owner of the vehicle. The same may be released to him by imposing strict conditions. Para having regard to the above. Dated 14/8/25 passed by the hereby set aside and it expected that the demand of the granted to the petitioner. Following conditions. For one petitioner cell of stroke vehicle. Of the trial. Color and get-up of the vehicle shall not be changed in any manner. Receipt has been submitted.
No, Lord, under investigation.
And when required by the IO or subsequently at the trial. However, petitioner is permitted to carry out necessary repairs to the vehicle. In revision petition stands this.
Deeply obliged, Lordship, deeply obliged.
The line लिखी थी हाँ.
My lord, 36 submitted, my lord.
Relax.
Charge number 675, 2000.
Yes, what is to be done?
Charge number 675/2025, dated 30/11/2025.
57 days custody, Your Lordship, and it was 60 days. I fear to allow me to go on bail, Your Lordship. Other two accused already released on bail, Your Lordship.
Who are you?
Amir Hussain. There was a dispute regarding money transaction, Your Lordship.
You were involved in the kidnapping or in the shifting?
Actually, the victim willfully come to my home, Your Lordship, on phone call, Your Lordship. He has to pay some money to us, Your Lordship, as per agreement. Agreement was to sell the dumper vehicle, Your Lordship, between the parties. Some money was unpaid, Your Lordship, on that issue.
which was 7 days will 60-day offense.
Mandatory 60 days,
my lord.
57 days. 58 days, 58 days.
127, 7 and 308, 5.
Three zero eight extortion punishment up to 10 years. And 127 clause 7 wrongful restraint up to 3 years and fine.
It's an order from CM. Order dated 20/10/25. 1, 2, 3. Submitted on behalf of the petitioner. The informant had come to his home. The settlement of a dispute regarding a dumper owned by the petitioner. 20%. Means that charge sheet has already been submitted by CS number so and so. Also 57 days in custody. Accused of the case granted bail, have been granted bail by order dated 23/10/25 in bail application 319 of 5. The above. Therefore, bail is allowed. Bail of rupees 20,000 with 50,000 with 1 security amount to the satisfaction. And CGM Kamrup. The trial regularly will not hamper, will not tamper with the evidence, hamper none. Allowed accordingly.
Blazes.
May I please, Your Lordship? My lord, case diary was called for FIR at page 16. What happened, my lord? A thief, my lord, he tried to enter into the nearby to my place, my lord, a Havells godown by climbing tree, my lord. Then he fell down because of the security guard. They saw him and probably due to that, some apprehension, he has fell down from the tree and maybe suffered some injury, my lord. Then myself, I have dialed 100 and I called the police, my lord, and we have handed over him to the police, my lord. Then he has died in the next day, probably in the hospital. When we handed over, my lord, there is absolutely no injury on his any part, my lord. No external injury was there, my lord. Even subsequently also we inquired, there is no external injury. Probably he has died due to the stroke. Probably suffered some, his health.
PM report is there.
PM report was called for.
There, my lord, but final cause of death has not been mentioned, my lord. These are
Injuries or anything of that sort.
Yes, my lord, there are some injuries, my lord, and even the heart also, my lord. Heart also clotted bath and has been found, my lord.
Let's see.
Injury in the heart.
My lord, yes. It is different.
Probably, my lord, no external injuries, my lord.
Otherwise, doesn't appear to be any other injury.
Whatever my learned friend has submitted, my lord, this is correct, my lord. Because my lord, thief was caught, he was handed over to police. Then in the police station, my lord, police has found him, my lord, suffering from some illness. Then he was taken to my lord hospital. He died, my lord. Now, when the CCTV footage was checked, my lord, then my lord, this person, my lord, it was shown that this person was assaulting them, my lord, thief, my lord. It is why, my lord, they have been named in the FIR, my lord.
Assaulting, all right. When a thief is caught, it is likely that some assault will take place,
Not to
but
that extent,
not
my
to
lord.
that extent.
Not to that extent, my lord.
That is the extent where we do not see any injury.
Yes. That the final report is yet to obtain, my lord.
That is meaningless, basically. Viscera analysis. Is it a case of poisoning?
Oh, not a case of poisoning, my lord.
It's a poisoning, my lord.
We are already 21 days, my lord, in custody.
Nowadays, it seems in every case they send the viscera for analysis. I don't know any instruction earlier. That wasn't the case.
We are already in custody for 20 days, my lord. And we have handed over him. We have informed the police.
Mr. M. Learned counsel for the petition. This is an application. Application is reflected in the higher. That a person suspected to be a thief was detained by some local persons near Havel showroom at Gorchuk. Upon being informed telephonically, the police proceeded to that place. The said person, who disclosed his name as Prahlad Kolita, was handed over to the police. Thereafter, took him to hospital for medical examination. However, the health condition of the said person deteriorated. Subsequently referred to GMCH. Subsequently, during that day, fired. Further appears that from the CCTV footage revealed that a group of local persons were seen assaulting the said person with sticks while detaining him. present petitioners are identified as some of the assailants submitted petitioners themselves who informed the police and handed over the suspected thief to the of the post-mortem report does not indicate injury. The period of detention of about 21 days. Bail is allowed. Bail of 1,001 security each. Provided that the petitioners investigation. States disposed of it. Send back the series.
Obligation, highly obligation. Received a case right of.
Facebook comment log. The page 27 is a comment log.
Has posted a Facebook comment relating after Delhi blast. That why this incident took place before election.
Page 27, the specific comment is there.
Retired army personnel lordship. As per his statement, he stated that yes, mentally really disturbed this because of these things he has posted. A post lordship. 20 days in custody.
Is 20?
20 days in custody.
Page 27, lordship, the specific comment lordship for which this FIR has been logged.
The account name is New Collection.
And has the next one also been arrested?
Not.
Below New Collection. Similar nature.
Similar nature.
Third Learned Counsel for the petition. This is an application under so and so. The only allegation against the petitioner is that he made a comment in social media in respect of the recent Delhi bomb blast, questioning as to why such incidents occur before the elections. Petitioner was arrested on
14/11, lordship.
14/11 and has spent about 20 days in custody. Having regard to the nature of the allegations, further detention is not considered necessary. Accordingly, the prayer for bail is 50,001 security.
Inspection of lordship SDGM M not Talmara.
No, no.
In bracket M lordship, not Salmara.
Not some.
Not Salmara, Abhaipuri lordship. Much obliged, much obliged.
Eight, please, your lordship. Your lordship, behind the bar for 245 days. Charge sheet already filed,
you
your
do?
lordship.
Absolutely nothing against them, your lord. Charge sheet already filed, let them face the trial, your lordship. FIR, the allegations charges that have been framed, your lordship, most of the offences are up to 3 years. Charge sheet does not contain any specific allegation against this petition. This honorable court has passed an order on the last date, your lordship.
Where is the charge sheet?
My lord, in this case, my lord, although scan copy has been called for, my lord, in the court, it is shown that, my lord, scan copy received, my lord. But actually, my lord, I have checked the record, my lord, the scan copy is not received, my lord.
Charge sheet, lordship, will find at page number 19.
What is this? What is so great about this charge sheet? Another bench has sent it to the DGP for sending it to the police academy.
Because the, my lord, what is the allegation, my lord, so will find in the page, page number 26, my lord, first paragraph, my lord. My lord, the serious one, my lord.
So we need to see the TCF.
Whether required, your lordship, 245 days as on today, your lordship, absolutely nothing, your lordship. When the medical report I have annexed, your lordship, medical report also
Absolutely
does not.
nothing means where from do we know that there is absolutely nothing?
I'll take your lordship to the medical report which is annexed. Lordship, FIR was filed on immediately after lodging of the FIR, both these petitioners were arrested on the basis of assumptions, your lordship.
Where is the medical report?
Lordship. We'll come to page number 15, your lordship. I'll read your lordship. On 1/4/2025 at around so-and-so, the following named patient got admitted in the civil hospital by so-and-so. The patient came with some unknown public. The patient was not escorted by police. The initial history was reported by the accompanying public, followed by the patient. She was admitted with the history of RTA. On examination, vitals normal, no external injury found. The patient got admitted in the FSW and later on she was shifted to the ICU. In the ICU, she was examined by the ICU in charge at around 10:35 p.m. on 1/4. As per her statement, she was allegedly physically assaulted inside a bus on which she was forcefully pulled in by some miscreants at around 4:50 p.m. So later on she was pushed out from the running bus at around 5:50 p.m. On arrival, vitals are normal, no signs of external injury, ECG, chest X-ray, X-ray of dorsal spine, so-and-so, so-and-so. All the reports are within the normal limit. The patient is being treated conservatively. This is so far as our external injuries is concerned. And then lordship will find the sexual assault report is also annexed. Absolutely nothing, your lordship. And are behind the bar on the day of the incident, or immediately on the next date of the incident, on the basis of some CCTV footage, your lordship, one driver of a bus and handyman of another vehicle, both of them were arrested, your lordship. Already charge has been framed, your lordship. And the charge that have been framed, lordship, most of the offences are up to 3 years punishment. Framing of charge, lordship will find at page number 19, your page number charge framed at page 30, your lordship. No physical injury, no any assault of sexual nature was also found. 28/2025 is the order, your lordship. Case record is put up before me. The PO is on leave. The accused persons are produced from the custody. Remand them so and so, fix so and so. Seen the petition number for the bail of the accused so and so. Hard both sides. In this case, charge has been framed under section 127(2),
35, 74, 76, 75 BNS. Now I have quoted down what are these sections, Your Lordship. 127.2 is section 342 CRPC, which relates to IPC, IPC, which relates to wrongful confinement. Then section 35, it is section 34 of the IPC. Then section 74 is 354, assault to outrage modesty. And section 75 is section 354A, sexual harassment, up to 3 years punishment. And section 76, section 354B, assault to disrobe, where punishment may from 3 to 7 years, Your Lordship. They are behind the bar. Let them face the trial, Your Lordship. Since the date of the arrest, they are behind the bar, Your Lordship. Medical report also does not a case of heinous murder or NDPS or something like that, Your Lordship.
That did not happen only because she managed to share her WhatsApp location.
Lordship.
Otherwise, you would have another Nirbhaya maybe.
Lordship. I could not get it.
Otherwise, we may have had another Nirbhaya type case inside the bus.
No, Your Lord. Even Your Lordship, that was what the court thought, that it might be like this, but absolutely nothing, Your Lordship. No physical, nothing, Your Lordship. It is, if the Lordship reads the FIR.
They were the driver and handyman of the bus, my lord.
Of two different vehicles. They
On
were
that
picked
day,
up.
my lord, on that day, my lord, that is my lord from the sergeant, my lord, I'm submitting, my lord. That is a scan copy maybe called for, my lord. We'll have to, my lord, see, my lord, what the victim guard is deposed in our 183 statement.
If the forwarding report, Lordship says, on what basis they have been arrested, that is provided, Your Lordship. Otherwise, Your Lordship, they will face the trial, Your Lordship. The girl on that very day itself recovered. She was medically examined, nothing of that sort, Your Lordship. And only this driver and handyman, Your Lordship. I have submitted a note that driver is of a different vehicle,
But whatever be there in the TCR, charges have been framed under these sections only.
Now, my lord, since it is a bail application, my lord, so we have to consider this application on merit, my lord. So what are the, my lord, these are the documents, my lord, he has produced, my lord. But my lord, there are one.
I have produced all the case record, Your Lordship.
My lord, victim guard is not.
No, the fact that the charges have been framed under these
Lordship
sections indicates what is the material available.
Yes, my lord, but even, my lord, if the materials are, my lord, suppose, my lord, the allegation of molestation, my lord. My lord, she was molested, my lord, an attempt was made. my lord.
That is there, that is
Attempt
there.
was there to commit an
That is
offense.
covered by 74, 75, 76, that is covered by the.
Question is that Lordship may peruse the scan copy, my lord, then Lordship may pass necessary order, my lord. This is my thing, it is already been called for, my lord, it is not received, my lord. Because we have to also make submission on the basis of the scan copy of the record, my lord. We cannot rely on the, my lord, the document annexed by the petitioner, my lord. It is just such that case, my lord.
You're disputing the documents now.
Oh, my lord, that we have to verify, my lord, from the scan copy, my lord. That is why scan copy been called for.
only for the purpose of keeping them behind the bars if they are satisfied that.
No, my
all
lord,
this-
I'm not saying that, my
all
lord.
the sections, Your
it may
Lordship,
fix
only
after,
up
my
to
lord,
3 years,
after
Your
a
Lordship,
month, my lord.
punishment. And they are
Lordship may
behind the
fix it
bars
any
all
date,
along.
my lord, any
It is a
date, my
question
lord.
of right to life and liberty, Your Lord.
Any sort that, my lord, see, it has already been called for, my lord.
That will happen on Monday then.
But the scan copy, my lord, has to be called for, my lord.
It was called for on the last date if they.
The reminder may be issued, my lord.
It is submitted, the charge sheet has been submitted. And though scanned copy of TCR was called for.
No, TCR was not called for. Only I think, Your Lordship, court did not call for the TCR.
Scan copy of the statement, my lord.
In fact, all the TCR records I have annexed, Your Lordship. All the court orders I have annexed. And the case is now pending for.
Scanned copy of the statement of the victim recorded under section 183 BNSS was called for. The same is yet to be received.
They can bring it today evening itself, Your Lordship. People are behind the.
Case, my lord.
You may be here in the evening, I'll not be there.
Then, Lordship. Submitting only.
And also scan copy of the charge sheet.
Scan copy may be called for, my lord, please.
It will take more time.
It will come, my lord, through online, my lord. Lordship, fix it on Monday, my lord. Lordship is already said, my lord.
Issue reminder and also call for the scanned copy of the charge sheet. the matter again on Monday.
I'm obliged, Lordship.
FIR is 9, Lordship. Petitioner is behind the bar for 54 days, Lordship. In this case, altogether 3 accused persons were arrested, Lordship, and 2 are released by your Lordship.
Educational volunteer, my lord.
Oh, education volunteer.
My lord. One of the educational volunteer, my lord, and he has also stated, my lord, that he collect money and, my lord, give it to Pallavi Soikia, my lord.
Pallavi Soikia is in interim.
How many days?
54 days, Lordship.
54.
Yes.
Michael.
Eh?
Michael, please. Arrested on 10/10, my lord. What 55?
Same order.
Obliged.
I plead your lordship. My lord, in this case, earlier, your lordship granted me bail. I am placing the order, my lord. He was originally arrested on 28/9/25. My lord, then after, my lord, your lordship had granted me bail. But prior to that, I was shown arrested again in this case, my lord, on 4th of 11. Today, again 1 month I have completed. Total my length of detention is 67 days, my lord. So, my lord, I take your lordship page 13. Kindly peruse the FIR. And there is no similarity of forwarding report and the FIR, my lord. My lord, in the FIR, it is submitted, informed that, page 13, my lord, it is respectfully submitted that on 11/9/25, at about 11:45 p.m., I parked the car near my friend's residence at Nandan Nagar, Barbari, and stayed there for the night. And today morning at about 4:30 a.m., I came to know that my car has been missing from the place where I have parked my car. I have searched nearby area, but I have no information about the car. My car number is such and such. A case under section 406 has been registered. My lord, then, my lord, I take your lordship forwarding, where I was shown arrested, my lord. That is page 16. Kindly come. Page 16, my lord. Page 16, my lord. With reference to the subject cited above, I have the honor to report that on 12/9/25, Biju Gao Khua, son of such and such of Presidency of Hengrabadi, Dispur Kamru, complained that his vehicle number such and such has been stolen. During the preliminary investigation, SI Biswajit Devnath of Dispur PS found that one Mr. Devojit Bhattacharya made an agreement and fraudulently taken away the vehicle Maruti such and such, bearing registration number such and such, engine number such and such, on dated 15/3/25. An accused came to his current resident, named Swaraj, resident Hengrabari, and approached him under the pretext of providing various works opportunities. Devojit Bhattacharya offered the complaint that and one vehicle in urgent need for monthly rent under the school purpose, and he has promised to Biju Gao Khua a payment of rupees 30,000 per month. After that day, the accused did not respond to the call of the complaint. Accordingly, the case has been registered in this PS case of such and such. Well, during investigation, it is found that there is a huge nexus of the fraud and cheating is going on, where the group of accused fall different victims in different traps to give their vehicle in monthly rent basis and in self-drive purpose. But for this purpose, wrongful gain, the accused illegally sold those vehicles at Manipur and Nagaland. In the current case, the vehicle was taken by Devojit Bhattacharya along with Deep Roy, a company. Deep Roy driven the vehicle from Guwahati to Hojai and then sold it 2.5 lakhs rupees at Manipur. This said that the accused Deep Roy already been arrested in connection with the Dispur case, but I have given the order to your lordship.
This is a different incident.
Different case. But my lord, there is no, FIR is something and forwarding is something. And my lord, 67 days. But the apex court the judgment that if any case is pending, they should show me immediately after my that I am warranted in all these cases. And I am sure, because I have lodged a complaint against torture, that human, I have annexed this. Kindly peruse this order of the CGM, page 18, kindly. How I was inhumanly tortured. So I lodged a complaint to the Human Rights Commission because of the finding of the land CGM, this order. The Human Rights Commission also registered my case and I have annexed the order, page 21. And I am sure if your lordship consider my this prayer, I will be implicated to another case. There is a tremendous pressure upon me to withdraw the cases. And today, the order was there, the third day, CD has not come.
He is a veteran card lifter, my lord.
I am veteran, yes.
Then,
But my liberty cannot be curtailed in this way, my lord.
He has been shown as my lord and my lord.
If I am veteran, put me under NSA. I will remain for 1 year.
My lord, only question is that, my lord, the vehicle in question, my lord, that has yet to be recovered, my
Oh,
lord.
I have not done in this
Let me
case.
submit this.
Yes.
Only point
In this case, my lord, my involvement is nothing. It is a projected matter by the IO.
Let the investigation complete, my lord. Because the vehicle is yet to recover, my lord, this is very important, my lord. Otherwise, my lord, there are several cases pending against him, my lord, and he is a veteran, my lord, car lifter, my lord.
You produce me what is the
He,
case?
my lord, he took the vehicle on rent, my lord. Thereafter, he altered the my lord, GPS system, then he sold to Manipur, my lord.
In this case, my lord,
There are
the-
incriminating materials against him, my lord.
let them produce the CD, but today also CD has not come.
The CD has come, I'm submitting from the
Then,
case.
then you show.
Where from I'll submit them?
Let you mark the CDM hand over.
Yes, ma'am.
Yes, next.
Please, your lordship, the matter may be taken next week, my lord. I have to take some instructions, my lord.
On the prayer
On
of
10, my lord.
council list the matter.
On 10, my lord.
Article number success submitted.
So,
I'll face the trial, my lord. Protection may be given, my lord.
till then, before the petitioner, an additional PP submits that charge sheet has already been.
Right, search sheet number, my lord, 121/2025, dated 38/2025.
On the prayer of learned counsel for petitioner, it is provided that the learned court below within 15 days from today of any bail application filed, the same shall be as per law pending such appearance. It is interim order is there, no,
No, my lord.
provided that petitioner shall not 50,000. Remain in force till 15 days, till expiry of 15 days from today.
Yes. Master bless.
61 attempt to deliver.
The appeal is held to be devoid of merit and is consequently dismissed.
For delivery of order, item from production list, item number 1. AB 1983 of 2025.
Petition is dismissed.
AB 2031 of 2025.
Petition is dismissed.
AB 2032 of 2025.
Petition is dismissed.
AB 2093 of 2025.
Petition is dismissed.
AB 2106 of 2025.
Petition is dismissed.
AB 2121 of 2025.
Dismissed.
AB 2123.
Dismissed.
AB 126.
Dismissed.
AB 2127.
Dismissed.
AB 2128.
Dismissed.
AB 2129.
Dismissed.
AB 2131.
Dismissed.
AB 2133.
Dismissed.
AB 2134.
Dismissed.
AB 2142.
Dismissed.
AB 2164.
Dismissed.
AB 2173.
Dismissed.
AB 2175.
Dismissed.
AB 2194.
Dismissed.
AB 2216.
Dismissed.
AB 2359.
Dismissed.
AB 2520.
Dismissed.
AB 2718.
Allowed.
Item number 32.
The second time my landed pen supposed to produce the sitting case there, my lordship today.
My lord, case diary not received, my lord. We have sent requisition.
The second time, my lordship. There is a new update, my lordship. The petitioner number husband, the accused number 1 is got bail by the after completing the statutory period of 90 days, my lordship. So husband and wife can cooperate with the investigation. If your lordship put in any condition your lordship satisfy, they can cooperate with the investigation authority, my lordship. And they will.
What is the FIR?
14, my lordship. 13, my lordship. Section 103 is involved, my lordship, but accused number 1 is already got bail, my lordship. She is the accused number 2, ma'am. And anytime charge sheet, ma'am, might file by the investigation authority also, my lordship. 3 months is complete. Husband is already out of bail, so they both can kindly cooperate to the investigating authority, and they will not hamper and temper any witness also. The lordship can put any condition, restricted condition.
Is the order of bail,
Sorry, my lordship.
bail order? Husband,
Husband's order, lordship, I have just telephonic conversation with the youngest counsel of that particular trial court. May it in the next, after 1 or 2 days, I will produce before your lordship. I have just telephonic conversation with the
Monday,
youngest
my
counsel.
lord, Monday.
charge sheet has been submitted?
No, my lord.
No. Oh. This again on month. They did not receive.
Deeply obliged, my lordship.
May it please your lordship. Case date was called for. Certainly, my lord, in search is submitted one. Some protection may be given. We will face the trial. Interim of hand.
Learned counsel could appeal. Learned additional PP submits that charge sheet has been submitted by
By charge sheet number 106/2025, dated 25/11/2025.
on the prayer of learned counsel for the petitioner. Application is closed off with the observation that the petitioner shall appear before the learned court below within a period of 15 days from today, and in the event of such appearance and filing of any bail application, that shall be considered as per. Till then, it is provided that the petitioners, the event of their arrest, shall be released on as bail of rupees security, satisfaction of the arrest. Protection expiry of 15 days from today.
I move less.
10:35.
But it is initially civil dispute matter regarding some water flowing. And both parties are from the same family, my lord. Now your lordship will, this is given attempt to murder. This is the whole problem, my lord. But in fact, to our information, or injury, nothing at all. And 2 FIR we have given earlier in point of time.
Receive.
Not one.
That time to remove one day, my lord, injury report is to be seen, my lord. Whether any injury is there or not, that much he can bring, my lord.
This is from Patasar Kusi, my lord. Lordship will fix it next day, next week, my lord.
They did not receive. Please again on 12 and so. Interim order passed earlier to continue till the next date fixed.
Baro.
Bhagavad, next week.
36.
Only if minus it's injury report comes, your loss will.
Come with, if the CD comes, it will
Yes.
also come.
Charge sheet submitted, lordship.
Lordship, LCR may be called lordship. Can copy of CD.
Submitted on 25/11, lordship only.
That's it. Learned additional PP submits that CS has been submitted by
168. stroke 25 dated 25/11/2025.
Call for the scanned copy of the TCF along with CD. Any interim is there?
What date? Before vacation, any date? Just scan copy, Lordship.
Interim, there is no interim,
19
give a early date.
19.
Much obliged.
Thirty-six to 37, 36.
37.
37.
PDF.
May, my lord, lordship will find my lord is FIR at page 10.
Received.
Received, Lordship.
Yes.
Now lordship kindly see, my lord, forwarding report by which the, my lord, the informant has been already, my lord, arrested. Page 20. Page 20 lordship will find Nawab Mullah, who is the informant. He is dealing in a, my lord, NDPS items. Because of that, my lord, we protest it in the locality, and ultimately she has lost this, my lord, false case against us. Page 20 lordship will find this gentleman who has already been arrested.
Yes, PP.
Yes, Lordship, what I have seen, Lordship, in the injury report, Lordship, it seems to be only one person, Nawab Mullah. And it is blunt object, simple injury, Lordship. And
Nawab Mullah.
Nawab Mullah, Lordship.
He is the
Informant, Lordship.
Okay, he is the informant.
He's the informant. So, Lordship, his injury is simple. And otherwise, this person's names are there in their statement of the victim. Two persons are their victims. All of them are named. And this person, the first one, Atwar Rahman, in his instigation, these all things they have done. It is stated by the victim, Lordship.
The hard learned counsel for the petition. Petitioner PP. This is an application number. So and so. The allegation as per the FIR is that the accused persons on 5/11/25 boarded the informant into a boat at the river bank and took them to a lonely area, tied their hands and assaulted them with lathi, the backside, leg and waist, also caused injury with dao on the head, who attempted to kill them. Para. It appears that the informant of the case himself has been arrested in connection with South Salmara PS case number 155 of 25 under section 21B/29 NDPS Act. On 14/11/25. There are learned additional PP upon perusal of the CD submits that some of the witnesses have indicated some of the petitioners, but the injury report only indicates simple injuries. Considering the above, therefore pre-arrest bail is allowed. 50,000 once you take. Go for it with the investigation. Okay. This
Deep law, please. May it please your lordship.
6 and 62.
May it please your lordship.
It is
Pre-arrest
available.
application, lordship.
It is available.
Lordship, here the petitioner happens to be the managing director and the principal of the institute, which is the subject in this particular matter. And as per the FIR, lordship, the petition number 2, who happens to be the principal, her name is implicated for uttering some defamatory words against the victim. Similarly, in the forwarding report also, in the statement of the victim, it is said that the managing director and the principal was involved in uttering some words against the victim. Now, the main brief of the fact is that the main accused, he has been already arrested and he has been terminated by the management subsequently to the filing of the FIR.
Who, the principal?
No,
who the teacher?
The teacher who was working as an employer in the institution. Now, the fact remains is that the apprehension that has been found by the managing director and the principal is that since their name is in the FI and at the same time in the forwarding report, in the statement, their names have been reflected. So they are apprehending that maybe some adverse action may be taken by the police against them. They are cooperating in the case since this case was registered on 3rd of November and on 4th, the main accused has already been arrested. And in the meantime, the principal and the managing director, they have also visited the police station and they have been interrogated and they are cooperating. But the fact remains is that now since 2 sections, that is 356(2), that is defamatory words, and at the same time 196(1)(a), that means some words that may be expressed by someone against somebody regarding some community, which may bring some ill will towards any community. So since there 2 sections are there, they are apprehending that some adverse action may be taken. So they need some protection. They are cooperating and they will again go and they will record their statement. Just they need some interim protection. In the meantime, the CD is already available now. This matter was listed on last occasion, and since there was some corrections which was to be done in the cost title, that is why this matter got a bit delayed, my lord. Already corrections been made.
What my learned friend has stated, lordship, it is true. The statements of 183 statements are also there. It is not against these 2 persons. Mainly, this is against the this person, Abdul Karim, lordship, the main person. He is the main person, Lordship. And what my learned friend has stated, 196A, they have stated only in the last few lines. Moreover, their statements are also there, Lordship. I found their statements. These two persons' statements are also recorded.
Third learned counsel for the petitioner and learned. This is an application under so and so. Submitted that the main accused of the case Abdul Karim has already been arrested and the petitioners are cooperating with the investigation by appearing before the IO, and their statements have also been recorded. The petitioner is the, or one is the principal of the institute where the informant was studying, and number 2 is his wife. And perusal of the FIR, the allegation against the present petitioners is that on coming to know about the incident involving the main accused, they verbally abused the tribe students by making negative comments. Having regard to the fact that the petitioners are cooperating with the investigation and also considering the nature of the allegations, custodial detention, interrogation of the petitioners be necessary. Here is bail is allowed. 20,000, 1 CRT each.
My lord, petitioner number 1 is the managing director and petitioner number 2, his wife is the principal.
Okay, 1 is managing director, 2 is. What is the other item?
Of like.
I'm appearing item number 6, Your Lordship. Abdul Karim, Your Lordship. The petitioner is working in that institute for the last 10 years, Your Lordship. There's no single blemish in his career till now except this FIR, which was lost 2 days after the incident as an afterthought, Your Lordship, as he has some dispute going on with the owners of the institute, and they are in a process to oust him, Your Lordship. Already 30 days behind the bar, further custodial detention may not be necessary, Your Lordship.
The CD, Lordship, implicating materials are there. There are 3 statements, victims are there, Lordship. There are statement of 183 and 180. All are there, Lordship. All are implicating, Lordship.
The petitioner is working in this institute for the last
And
10
he
years.
is in
Lordship.
an,
No blemish in his
please-
career.
He is in a
Blemish means nobody came forward.
Lordship.
Lordship,
It is also stated here, Lordship, in the victim statement, it is also stated that because of afraid of that, Lordship, they could not come out.
Lordship, already 30 days behind the bar, further custodial detention may not be necessary, Your Lordship.
I have objection, Lordship. And moreover, he is in a predominance position, Lordship.
Lordship will, if he has any such attitude, Lordship have already granted bail to the management of the institute, Your Lordship. They would have known him if there are some other complaint also regarding him. But there are no such.
Alright, you pass over the CD. We'll see. Temporary.
Oblige, Your Lordship.
Please, Your Lordship, as per order dated 21st/02/2025, this Honorable Court give a direction to
Respondent number 3, fresh step. We have already taken.
It is submitted that steps have already been taken by the petitioner. On whom? You have taken steps on?
Respondent number 3.
And number 3. Have its service. List the matter again on.
I am for the respondent number 2, 4, and 5.
Forty.
Hello, it is for the delay of 92 days, my lord, this should hold on. If no objection, my lord, may be condoned.
My lord, paragraph 3, my lord, he has stated the reason of my lord delay.
How many days? 82.
92
days.
is not explained properly, my lord, in accordance. Only 4,000 and 1,000 granted, my lord. The first paragraph, my lord, quantum of maintenance is stated. That the present division of petitioner was directed to pay an amount of rupees 4,000 to the respondent or the
So let us
maintenance.
condone the delay and dismiss the petition. Operation successful, patient died.
Delay may be condoned, my lord. And after hearing, may be dismissed or may be allowed, my lord, that is up to your lordship.
Learned counsel for the petitioner and learned for the respondent also heard learned them. It is party.
I am number 2, my lord. Actually, state is not necessary, my lord, but state is also made party.
SIA has been preferred seeking condonation of delay of 92 days in preferring the present revision. It is stated that paragraph 2, okay, IA. Paragraph 3. I've heard learned counsel for the petitioner as well as learned having regard to the reasons for the delay stated herein above. appears that the petitioner was prevented by sufficient cause from filing the petition in time. Accordingly, the delay is condoned. I stands allowed. Criminal to give passed in IA 174 of 20, the matter for admission on given date.
Obliged.
Obliged.
Yeah, please, Lordship. As per the previous order, copy has been served to the land amicus curiae.
I'm appearing for respondent number 2, Your Lordship, as a matter of
The recorder also there, matter may be fixed up for hearing, Lordship.
Wait. Third learned counsel for the petitioner. Third learned amicus
negotiable instrument.
and
Possible.
LCR scanned copy of TCR has been received.
So it is a decided case, appeal against acquittal.
Appeal against acquittal.
Yes,
So LCR is here.
here, it is.
Scanned copy of TCR is available. Hence, is the matter. We'll fix it for hearing then.
Yes, Lordship.
Bill is admitted for hearing. The matter on.
I'm deeply obliged.
May please minutes. But I beg to appear for the appellant Millets in item 42 minutes.
So what is this about?
Millets, this is an appeal, Millets under NDPS Act, Millets. Today, Millets, this is for suspension of sentence, Millets. Millets, the appellant has undergone 2 years and 11 months of custody and is convicted under section 20B 2C, Millets, read by 29 of the NDPS Act, Millets, for 72 kilos of ganja, which is alleged to be found from him along with 4 other co-accused persons, Millets. But there are 2 major contraventions which have been taken, which have been an oversight by the prosecution. And one is that insofar as the samples are concerned, it is the case of the prosecution, Millets, that from the room, from the hotel room from which this contraband is alleged to have been found, Millets, that 9 bags were found, which contained, Millets, 30 packets of ganja. But Millets, the procedure which is enshrined under the NDPS rules has not been followed, where the sample has to be drawn from each packet, Millets. And there are various authorities, Millets, of the Apex Court and other honorable high courts as well, that if this procedure is not followed, Millets, it renders the conviction, Millets, liable to be set aside, Millets. And
Record is not available.
Millets, it has been served to us already, Millets.
No, the trial court records.
Please, Millets. The paper book has been prepared in this, Millets.
How is paper book prepared without the records?
We don't have paper.
I have been served, Millets. And my counsel was able to obtain it from the registry, Millets.
See, paper book is here. Record is here, it seems. Original record is here, it seems.
Millets, I'm only relying on the testimony of PW7 for this, Millets.
Maybe fix for final hearing, record. We have
I'm
not gone
only
through.
pressing for suspension of sentence today, my lords, if your lordship may permit me to just
In the
show
court-
my judgment.
In the court list, it has not shown lordship, so we have not gone through. In 42, 43, in the court list may look into lordship.
Yes, the physically the records are present, but
Please, my lords.
not shown in the cause list, so prosecution doesn't have access to it till now.
My lords, I'm only relying on one judgment. If I may be permitted to show the rest, I'm in your lordship's hands in that case, my lords. Or if your lordship would like to, my lords, defer this hearing for next week when the prosecution.
Yes, let them go through the
Please, my lords.
record at least, and we'll have it
Lordship.
on the next week.
Please, my lords. Your lordship may please give a fixed date, my lords, because it was listed after 3 months, my lords.
Had learned counsel for the appellants as well. An additional PP, it appears that the TCR has been received, but not shown in the cause list. Learned additional PP pays for some time to go through the same. Hence list the matter again on, give a date next week. Do you have any particular date?
No, my lords, as per your lordship's convenience, please.
Well,
Deeply obliged, my lords.
Lordship, service report in respect of respondent number 2 is awaited. Service report in respect of respondent number 2 is still awaited, Lordship. The Lordship may kindly allow me to take steps through the officer in charge of the concerned police station. Otherwise, it's a
all right, service in respondent number 2 not yet complete, as prayed for by the petitioner. Petitioner is permitted to take steps through concerned PS. List the matter again on.
Right.
Please, your lordship, this is an application for condemnation of delay of 190 days in referring this revision petition, lordship. Our criminal appeal before the learned sessions judge has been dismissed, lordship. Thereafter, we've come before this honorable court.
Which I am making for the respondent number to allow me to produce time to file objection.
Right, as prayed for by learned counsel for the respondent number 2. How much time do you need?
R. Burua.
How much time do you need?
4
2 weeks, huh?
4 weeks.
4 weeks.
Fix a shorter date because the learned trial court may proceed against me.
It will be vacation anyway.
A fixed date at
2
least,
weeks.
lordship.
Is for 4 weeks time to file objection. List the matter and give an agreed date. Much obliged.
Right, please, Your Lordship. I have before Your Lordship is a petition for condonation of delay of 154 days. Notice was issued, Lordship. On 3/11, we have taken step on the respondent number 2, but till that, no service report has come. There is a jail appeal, Lordship. Amicus curiae may be appointed for the respondent, Lordship. State of Assam is there, but respondent number 2 is the informant because since he was convicted under Section 8 of POCSO Act, therefore we made the informant as party in the case. Otherwise, there is a delay occurred due to official communication because case has come from the District Legal Service Committee to Guwahati High Court Legal Service Committee.
The informant necessary for condonation of delay, this is a jail appeal. We should not keep it pending for.
Otherwise, Lordship, this is a POCSO case. Otherwise, Lordship, it is jail appeal, Lordship.
Jail appeal.
Lordship, maybe.
This is an application for condonation of delay of 154 days in preferring the connected appeal against the impugned judgment and order dated 9/8/2024. The appeal has been preferred from jail. And on account of the reasons in the instant application, I'm satisfied that sufficient cause has been made out for condonation of the delay. Accordingly, the delay is condoned and I is allowed. Connected appeal to লিখিব in view of order passed in IA 982. Appeal is admitted for hearing. To notice to the respondent number 2 by registered post with AD within 3 days. To take steps again on the, we have condoned the delay, but as far as the main appeal is concerned,
Let it be numbered first, Lordship.
it is numbered, I think.
No. After condonation of delay, it will be numbered. Without making the delay condone, Lordship.
No, what is this number? Criminal appeal
Serial-
J2319?
Serial number.
It is only
Filing-
serial number.
Filing serial number. Registry may be directed to, Lordship, number the criminal appeal as well as connected petition, Lordship.
Registry is it appeal not lage. Ek tolot likhi dile to directed to registered appeal. Place the matter again on.
Connected petition, Lordship. There is a petition.
I had to take, huh? Okay. Is the connected appeal on after registration list that case stands disposed of.
Early of Lordship.
39.
May I plead your lordship? Lordship, in this case, the service is complete, lordship. And earlier filed the additional affidavit of the service report, lordship. And thereafter the person ordered the service is complete, lordship. And fixed this case, lordship, admission hearing in the next week, lordship.
Service on respondent number 2 is complete. List the matter for admission on.
Next week, lordship. Bless, lordship.
Yes.
Lordship, in this matter, the case diary hasn't been received yet. Exactly.
Same as last order. Give the dates.
Much obliged, Your Lordship.
May I please, your lordship? I'm appealing for response number 2. But on earlier order, madam, if your lordship peruse the order dated 22/5,
Order dated
order 22/5, 22 May 2024. But they assured us to pay the entire amount in 3 installments. Now they are paying 10,000, 20,000, 15,000 just before the date. It's before this court, madam. Yesterday also, madam, they have paid an amount, madam, of 15,000 rupees, madam, just before the date.
No amount is mentioned here. It is simply said, pay the money in installments.
3 installments, madam. 3 installments. Madam, as per the order date 22/5, madam. the Nane Consumer-
22.
22. 22/5, madam. The Nane
It's
Consumer-
22. We have only 13.5.
Madam. 22/5, madam.
13. In the main petition.
Yes, madam. The main petition, madam. In 49.
13. 22.4, then 13.5, then 13.6.
It is 22, madam. Document.
24.
22/5 with 2024.
2024. Last year's. order.
24.
Yes, madam.
Yes, it is.
Yes, madam. As per this order, my lord, they are supposed to pay us in 3 installments. But now they are paying 10,000, 15,000 just before the date is fixed, madam. Yesterday also, they have paid a amount of rupees 10,000, 15,000, madam. Now, the total due remains, madam, at madam 6,05,000, madam.
So far, how much has been paid?
Madam, now remaining is madam 6,05,000, madam. Out of 13,20,000, madam.
Initially, 6,20,000 was paid.
Madam, initially, my first payment was made on 13/7/2024, 3 lakhs. And on 15/12/2024, 1,20,000. Now the total due remains 6,05,000, madam. You have to pay us.
So what do you want now? 6,70,000 you had received till July.
Yes, madam.
Till June.
Hello. June, madam.
Well, it is, we are taking some time, but we will pay, my lord. We are paying. He is also going through some financial hardship, my lord.
She's a doctor, madam. She's a doctor.
What to do? Either you want your money or you want.
Yes, madam.
Last payment was made when?
Yesterday.
Yesterday. How much?
15,000, madam.
15.
May I comply with the order date 22/5 that the insurance was given, madam, before this court. 22/5/2024. In madam, this amount, remaining amount may be given in 3 installments, madam. That also I am agreement. This remaining madam 6,05,000 rupees. That means this also may be paid in 3 installments, madam.
Within a period of?
In a period of madam. 3
I
months,
need to
madam.
get some instruction regarding that. I need to receive some instruction regarding that.
Is submitted on behalf of the respondent that an amount of 15,000 has been paid yesterday. Learned counsel for the petitioner seeks time to obtain instructions as to the period within which the remaining amount will be paid, can be paid by the petitioner. Hence, list the matter again on 2 weeks.
Madam. Madam. Obligation.
None appears for the appellant. List after 4 weeks. List is over.